So my name is Marco Borraccetti. I'm an associate professor on European Union law at the University of Bologna, and my focus of research is on migration and refugee law, and specific on the sector of trafficking in human beings. But I'm interested on, in general, all the matter of mobility and movement inside and to European Union from a legal perspective. Furthermore, I am the delegate of the rector for the refugees, scholars, and students. So I am in the position to implement or to have the effective application and implementation of what is said at the EU level and at the national level for these persons. And also I'm co-directing a master on human rights and democracy in Southeast Europe that the University of Bologna lead together with the University of Sarajevo, and it is based in Sarajevo. When we are speaking about refugee law, one of the most important judgment of the Court of Justice is the recently issued judgment on Iaz and Cappelli, and it is about the concept of the principle of the safe country of origin. It is not the only one, because it follows the judgment issue in October 2024 by the Court of Justice in the case so-called CV, that was a Czech case. But this case has had a huge impact on the Italian legislation, on the Italian legal framework, and had also a huge impact on the political decisions. So that's why there was somehow a clash between the judicial decision and the will of the government and the politicians. And that's why it became very important at the national level, all the decision of the Court of Justice in this subject. It has an impact on the protocol that was signed between Italy and Albania, and above all on the implementation of this protocol. 2 words on it. It was a protocol signed by the 2 governments, Italian and Albanian, and according to which third country nationals coming from a safe country of origin, rescued at sea by the Italian Navy and applying for asylum, would have been detained in this center in Albania. But following the decision of the Court of Justice CV, the competent judges were not validating the decision of detention issued by the administrative authorities. It has impact on the procedure, because it means that these persons, instead of being detained in Albania, they were detained in Italy, and they were not subject to the fast track or the so-called border procedure, but they were subject to the ordinary procedure. But what is more important at the European and international level is that put in question the practice of externalizations of the migration management. In this situation, the externalization is because the centers are not in a EU member state, and are centers that are built in Albania, but under the Italian jurisdiction. In practice, what was the effect of the application of the principle issued in CV is that the Italian judges were not validating the detention of person in Albania, considering that their country of origin was not safe, because part of the country was not safe, or because part of the population was not safe. This extending the application of the judgment of the Court of Justice in CV that was speaking just about the territorial limitation, territorial exception in a state, but it was confirmed by the following judgment of the Court of Justice issued the 1st of August, Aiazze Campelli, that applied the same principle also for exception of group of people. So in the current situation, according to EU law, a safe a country of origin could be considered safe just if it is safe in a uniform way, if there are no exceptions. It is a situation that for sure put at risk the idea of externalization or put under pressure the competent authorities facing the massive inflow of migrants that are coming to the EU. But anyway, it is coherent with the judgment, the previous judgment of the Court of Justice, not just the one on CV, but in general on the criteria that the Court of Justice followed in the past to give interpretation of the directive or of the regulation. What would be the future? The future will be different, or at least slightly different, because according to the new regulation that will be applicable from June 2026, even if already enforced, the state will be allowed to identify as a safe a country even with some exception, territorial or for group. They will be forced to specify in which condition or for which reason the states are not considered completely safe. But it will be useful, or better, the judgment of the Court of Justice, both CV and Aiazze, will be useful for other perspective. For example, on the primacy of EU law on the national law, or if we are speaking about the judicial control of the decision, not just on the denial of asylum, but also on the way the member states will create the list of a safe country of origin. In this situation, in cases in front of the judges itself will be allowed to make a control of the proportionality of this list, and anyway on the fact that some countries are inserted in the list of safe countries of origin as an evidence, is supported by international documents coming from international organizations, from the EU or from NGO. It means that anyway in the future the judges will be allowed also to not apply a list where the decision to insert a country in the list of safe country of origin will not be supported, or if the conditions changed after the insert in this list. From a political perspective, I think that it will anyway could be a tension with the political intention to have the externalization of the detention of asylum seekers at the borders, or in general the externalization of the procedure of the European Union, meaning externalization on the fact that people will be hosted abroad. At the same time, we'll be very interested to see how the member states and how the Commission will be able to respect the principle of transparency and the obligation of disclosure that will be requested to protect the right of the applicants to have the access of justice following Article 47 of the Charter of Fundamental Rights and the Article 6 of the Convention of Human Rights.